Are you the spouse of a United States citizen who passed away before the permanent resident process could be completed? Are you worried that you're out of luck, that your green card dreams are gone, vanished, poof, in thin air? Have you been told by others, friends, or family members that when the petitioner died, your spouse, the petition also died? In general, that's true, but there are options for immigrant widows. We're going to explore those options. We're going to find out if there's a path for you to become a permanent resident, even if your United States citizen spouse has passed away. Let's begin. Generally, there are 5 key items we need to look at. 1, was your spouse a United States citizen on the date of his or her death? 2, was an immigrant relative petition filed by your spouse before they passed away? 3, were you and your spouse still married at the time of his or her death? By that I mean not just that you weren't divorced, but also that you weren't legally separated. 4, how long ago did the death occur? And 5, since your spouse's death, have you remarried? The first is, what's the immigration status of your spouse on the date of death? Was he or she a United States citizen on the day of death? If so, we can move forward to the next question in terms of the widow's visa. Now, there are options for spouses of lawful permanent resident, but they fall under a different section of law, and they're slightly more complicated. But if you've been married to a United States citizen on the date of death, then you can move forward with a widow's petition as long as you meet the next 4 requirements. Now, note, that means that your spouse could have been a naturalized citizen and that you spent several years with that person before they became a citizen. That doesn't matter so long as on the day they died, they were a United States citizen. The second requirement is, did your spouse file a petition for you? If they filed a petition for you, was it approved or is it still pending? As long as your husband or wife filed a petition for you, whether it was approved or it's still pending, that petition will be automatically converted by the government into a different petition. The petition filed by your spouse is known as an I-130 immigrant relative petition. When the government converts it, it will move into an I-360 self-petition, meaning that from that point forward, you go on into the next step as a self-petitioner on your own. So what happens if your spouse did not file a petition for you? Are you out of luck? No, because you can file the I-360 petition, the self-petition, on your own at that point, and you would still be considered a spouse of a United States citizen, so long as the other requirements are met. Let's move to the third requirement. Were you and your spouse still married on the date of their death? Were you still together as a couple? If you were divorced or legally separated, then you will not be able to go forward. Now, here's the thing. Some couples find themselves torn at times in their relationship with the other spouse, and they may move out, a cooling out period. That doesn't mean they're legally separated. Legal separation is a formal court-ordered status, very close to a divorce. And there'll be certain rules that the court has set forward, certain orders that the court has set forward, such as child support, child custody, division of property. If you have a legal separation order, then that's pretty much like a divorce. You're going to be out of luck. But so long as you haven't been divorced and there is no legal separation order, you're fine. You can move forward into the next step. Fourth, how long ago did your spouse pass away? You have to file within 2 years of your spouse's death the self-petition if a petition hasn't already been filed for you. If you have to start the process, you need to start it within 2 years of your spouse's death. What happens in many situations is that individuals who have lost a loved one listen to their friends or their family members, and they think they can't do anything, and they let time go by and time go by until one day they stumble across the fact that maybe they can go forward. Be careful, because you need to file within that 2-year period of time in order to seek permanent resident benefits under your relationship with your United States citizen spouse, even if they have passed away. The fifth criteria is, have you remarried since the death? And if you have, you're really out of luck there as well. You will not be able to go forward. But this is where the law can get really tricky. Because up to now, I've been talking about a widow's petition. There are provisions under another section of law, 204L of the Immigration and Nationality Act, known as the Survivors Act. And so the surviving spouse can still go forward under this provision if they've been remarried. However, there are 2 requirements that you must meet there in order to continue your case. First is that the I-130 petition has to have been filed by your spouse before he or she passed away. It can still be pending, but it has to be filed. So in the situation where there was not a petition filed before your spouse died, you're going to be out of luck. The second requirement is going to have to deal with the issue of where you lived with your spouse and where do you live now. In essence, it means that you have to have lived in the United States with your spouse at the time of his death, and that you still have to be living in the United States now. If that's not your circumstances, then again, you will not be able to avail yourself of the rules under 204L. However, the residency requirements, and like I said, the law gets pretty tricky here, you might be able to overcome by filing a request for humanitarian reinstatement. But that's really complicated and would change the nature of your entire case, because now you have to win discretion from the government. They have to approve your request to reinstate the petition because it was cut off because you didn't meet all the requirements. And that's really hard because you're going to have to show a lot of requirements, more along the line of hardship requirements as to why you need to continue the process. They'll look into your history in the United States. They'll look into your health in the United States. They'll look into your past records. But that doesn't mean it can't be done. It doesn't mean you can't be successful. And in fact, if you're in that situation where that's your only option, well, then that's your only option. So you're going to do it. You're going to put your best foot forward, and you can succeed. So I hope that I've been able to explain to you and give you some hope that you can become a permanent resident, even if your United States citizen spouse has passed away before the green card process was completed. And note that under 204L, that if you were married to a lawful permanent resident, you would be able to go forward if you can meet all the requirements. In any event, I wish you the best of luck. I hope that you can continue with your petition and that you don't stop at becoming a permanent resident, but you continue going forward until you're a United States citizen. Take care. Best of luck. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below or feel free to contact me at carlos@VitaraImmigrationLaw.com. My name is Carlos Vitara. I appreciate your time and hopefully we'll be talking again very, very soon.